Okay, hello class. Today I'm going to be dictating your tests only, so make sure you access the speed building and then listen to your tests, okay? So on your first test, you have proper names. You have Defendant Thomas, Crested Butte, Miranda, and Gunnison. So this is going to be your test number 1 for 5 minutes, 140 lit. Defendant Thomas is charged with aggravated robbery and conspiracy. He filed a pretrial motion to suppress statements made by him to police officers and physical evidence seized from his house. The trial court granted this motion, and on this interlocutory appeal, the district attorney asserts that the trial court's ruling is erroneous for several reasons and should be reversed. The record before us reveals an abuse of discretion on the part of the trial court when it refused a brief recess to permit the deputy district attorney time to produce certain items in court. We reverse and remand this cause for a new suppression hearing. A grocery store in Crested Butte was robbed at approximately 5 a.m. Police officers were called and promptly appeared at the scene. They followed 2 sets of footprints in newly fallen snow to the house, occupied by the defendant and others. When the defendant and the other occupants of the house were initially questioned by the police, a tape recorder was utilized. Thereafter, it was discovered that it was not recording. The defendant and other occupants of the house were therefore again interviewed in the presence of a tape recorder which was operating properly. At both of these interrogations, the defendant made statements relating to the robbery. The house occupied by the defendant and others was also searched, and items of physical evidence were seized. In connection with this search and seizure, the defendant signed a consent to search form. The day before the suppression hearing, the defense attorney had orally requested the deputy district attorney to produce the suppression hearing and above described tapes and the signed consent form. At the suppression hearing the following day, the defense attorney made it known to the trial court that the deputy district attorney had not produced these items in court. The record reveals that the deputy district attorney explained to the judge that these items had not been produced because he failed to remember the oral request by the defense attorney the previous day. He went on to explain that he had previously opened his entire file to the defense attorney, and his failure to bring these items to the suppression hearing was not a matter of bad faith or an effort to conceal any evidence. The crucial issues at the suppression hearing were the sufficiency of the Miranda warnings to the defendant before he gave any statement to the police, and whether the defendant had voluntarily given his consent to the police to search his house. As the district attorney was questioning his police witnesses, objections were interposed by defense counsel when the witnesses were asked either about the warnings given to the defendant or about the consent to the search matter. The objections were grounded on the best evidence rule. The trial court sustained these objections, indicating that since the deputy district attorney had been requested to produce the tape and the signed consent form and had failed to do so, he would bar any testimony regarding the warnings to the defendant and whether the defendant had given consent to search his house. The transcript of the suppression hearing reveals that the deputy district attorney then told the court that the tape and the signed consent form were located at the police department in Crested Butte, and that if he could have a very brief recess of less than an hour, he would have a police officer from Crested Butte drive to Gunnison, the location of the court, with these items. This request was made at approximately 11:30 a.m., at which time the deputy district attorney also suggested to the court that the tape and the signed consent form could be delivered immediately after the noon break. To this, the judge replied, "We will be through with this motion before we eat lunch." Thereupon, the court made a finding that there was no evidence that the defendant understood his Miranda rights or that he knowingly waived these rights. The court also found that there was no evidence of any kind that the defendant consented to the search of this house, and that the written consent, which was supposedly signed by okay, and then we have on your 140 number 2 lit test, proper names: Kent County Circuit Court, Jim Kim, Allstate Insurance Company, Ford, Route M57, Greenville, Michigan, Bob Sims, Chevrolet, Bert Doyle, Kraft Foods, Michigan Vehicle Code. And this will be 140 test number 2 for 5 minutes. This is an appeal from the Kent County Circuit Court by plaintiffs Jim Kim and the Allstate Insurance Company. The controversy arises from an automobile accident which occurred on December 21, 1988 at about 6:05 p.m. Plaintiff Jim Kim was driving a 1987 Ford pickup truck in a westerly direction on Route M57 west of the city of Greenville, Michigan. Bob Sims was driving a 1978 Chevrolet pickup truck in a westerly direction on Route M57. The 1978 Chevrolet truck was owned by the defendant, Bob Sims. Defendant Bert Doyle was driving a 1987 Ford truck owned by Kraft Foods in a westerly direction behind the plaintiff Kim's truck. Testimony on trial revealed that Sims and Doyle were traveling approximately 200 feet to the rear of Kim's vehicle. Plaintiff Kim contends that when he was about 300 feet east of the point of the collision, that he observed a vehicle approaching from the west with its high beam headlights operating, and that when his car came within 200 to 240 feet of the impact, the oncoming lights interfered with his vision. Plaintiff Kim further contends that he started to slow his vehicle by removing his foot from the accelerator as his vision became impaired, and that when the vehicle with the bright lights passed his car, he then observed an outline of the bed and axle of defendant Sims's truck stopped on the highway about 100 feet in front of him without any lights on the rear of the truck. Kim further testified that he immediately applied his brakes, pulled his car to the right partially onto the shoulder of the road, striking the rear portion of defendant Sims's truck and causing Kim's vehicle to swing around in a southerly direction, blocking the westbound traffic lane, at which time the defendant Dole's vehicle struck the left side of Kim's vehicle. Plaintiff's declaration alleged negligence on the part of the defendant Dole for failure to maintain a proper lookout and observation on the highway, failure to have his vehicle under control so that it could be stopped within the assured clear distance ahead, and failure to keep and maintain a proper and safe distance to the rear of Kim's vehicle. Plaintiff Kim further alleged defendant Sims's negligence consisted in failing to have the lights operating on the rear of his vehicle as required by statute, failing to give adequate warning of a stop or turn on the highway, driving carelessly and heedlessly in disregard of others' rights on the highway, creating a sudden emergency situation for the plaintiff by stopping on the roadway without lights. Plaintiff Kim also alleged gross negligence by defendant Sims in allowing his vehicle to be driven in the nighttime without lights on the rear of his vehicle. Defendant Sims filed an answer denying negligence and alleging that the sole and proximate cause of the collision was Kim's negligence in failing to drive his vehicle at a speed so as to permit him to stop within the assured clear distance ahead. However, Sims testified that he knew that His truck had no lights on the rear on the evening of the accident, and that he made no effort to warn traffic behind him. Defendants Dole and Kraft Foods filed their answer and affirmative defenses alleging that plaintiff Kim was guilty of negligence, which was the proximate cause of the collision between them, in that he failed to stop in the assured clear distance ahead, failed to operate his vehicle at a careful and prudent speed, and on the right half of the roadway, failed to make proper observation of the vehicles ahead of him in time to avoid hitting them, failed to give a timely signal of his intention to stop or turn, and followed defendant Sims's vehicle too closely, all in violation of the Michigan Vehicle Code. The case was tried to a jury. Motions were made during trial by the defendants for a directed verdict. These were reserved and the case was submitted. Verdicts in favor of the plaintiff Kim in the sum of $16,025 and the, little tough you all. And so we have your 120, number one. Proper names, you have Mr. President, United States, President, United States Senate. You have Arms Control and Disarmament Act, Nuclear Weapons System. Okay, this is going to be your 120 lit. Number one for 5 minutes. Mr. President, putting it quite frankly, I simply do not know whether the United States should proceed with production of this weapon. But my point is that I do not think the members of the Senate can possibly know either. In a word, the administration has not until just this hour complied with the requirement in statute that Congress be given, along with the request for funds and evaluation of the impact of this weapon on our efforts to achieve an arms control agreement. In the absence of a chance to study and hold hearings on this analysis, I find no compelling justification for going ahead with the funding. Now, we were told yesterday that the president continues to insist on funds for production of the neutron weapon, funds in the bill before us. He has not yet, however, made up his mind on actually proceeding with production and deployment. I was interested in the last speaker who discussed at some length the fact that the president has already made up his mind. I think he should read the president's letter dated July 11, and he will see that the decision has not been made. No final decision has been made by the president. I am simply saying that if the president cannot make up his mind on the basis of information available to him, how can the members of this body make up their minds on the basis of even less information? After all, we are a separate branch of government. We have to make an independent decision based on the facts as we know them. I think it is quite clear in listening to the debate here and other discussions that the majority of the members of the United States Senate do not know the full implications and nature of the weapons system we are talking about. We do not have the information, just as the president does not, to make that kind of a final decision. Let me just go back for one moment and point out there is an Arms Control and Disarmament Act provision in the law, which requires that Congress be given an arms impact statement along with requests for appropriations and authorizations for nuclear weapons. Congress is supposed to have this in hand during consideration of the funding, not the day of the vote. It is relatively of little use to look at it 2 hours before we have to vote. Any request to the Congress for authorization or appropriations for the program should include a complete statement analyzing the impact of such programs on arms control and disarmament policy and negotiations. Now, that has not occurred. It was not available to Congress either for the authorization or appropriation of funds for this weapon until an hour ago. If we are to subscribe to the idea that at this late stage, this report fulfills the real requirement, what we are saying in effect is we do not choose to abide by the law which we ourselves passed. Mr. President, we were told the report was mislaid. We were told it would not be ready until August 15. Suddenly it shows up today. On what basis then should we now appropriate these funds? On the basis of an impact statement that I suspect not more than 5 members of this body have seen. I think that is not a very solid basis for proceeding with a new weapons system in the nuclear area. Let us rather first see what this weapons system is all about, and then let us decide whether it should be funded. And then we've got your second 120 test. You have Madam President, Senator, Georgia, Korea, 3/5, Arizona, filibuster, United States Senate, South Carolina, World War II, Selective Service System, House of Representatives, Lend-Lease, World War II, Lend-Lease Act. This is going to be 120 lit number 2 for 5 minutes, you all. Madam President, I would like to say to the senator from Georgia that I believe that my amendment would cause greater discretion in declaring national emergencies, and it would cause Congress to think twice about letting national emergencies run on indefinitely once they have been declared. The emergency declared when we were at war with Korea, I think people just sort of forgot about and only repealed it when it was brought up by someone who thought it was about time to end that national emergency. The Congress would certainly be reluctant if we had a constitutional amendment in place requiring a balanced budget to frivolously declare national emergencies or leave them long-standing just as a device to get around the constitutional amendment. I do not think that would be done. One problem with the matter of expecting we can easily get 3/5 when needed to permit spending for national defense purposes or otherwise is the difference of opinion over what circumstances confront us. There may be those who perceive a national threat, and there may be those who do not perceive a national threat. There may be those who perceive a national emergency other than a national defense emergency, and there may be those who do not perceive such an emergency. The requirement for a 3/5 vote in order to be able to meet our needs places an undue burden upon the government and the responsiveness of the government. I would like to also point out, and this is in response to the question raised by the senator from Arizona, that if there is a serious doubt about the need to declare a national emergency, then it would not be done by a majority vote. There would be a filibuster in the United States Senate. We would therefore get right back to the need for 3/5 or 60 votes in the Senate before we would declare a national emergency. You would have to get closure before you could proceed. So I do not think we have to worry about this opening a debate loophole. I would also like to point something out once again to the senator from South Carolina, who thinks it would be so easy to get 3/5 anytime. There are those who perceive there is a national emergency requiring significant defense spending without my amendment. We have had some very, very close votes in the history of our country on momentous matters that required defense expenditures. If we had not been able to proceed without a 3/5 vote, we would not have proceeded. For example, on the eve of World War II, there was an incredibly close vote on whether or not to adopt the selective service system. It passed the House of Representatives by only one vote. It would not have passed the House by a 3/5 vote, and plainly some heavy expenditures were needed. It passed the Senate by a very narrow vote. Then we came to Lend-Lease. Lend-Lease was blocked for a long time in this body. Eventually, it was approved, but again by a very narrow margin. This is an example of where the majority prevailed and prevailed wisely. If they had needed 3/5 to take those steps, they might not have been taken in a timely fashion. Our casualties might have been far greater in World War II, a war which we might not have been as well prepared to fight if we had not in fact adopted the selective service system or the Land or Lend-Lease Act. The world. Okay, and so that's it, you all. Those are your tests. So hopefully you're just doing them as dailies. They're just a little tough, okay? Have a great day, you all, and let me know if you have any questions regarding anything.